Welcome to today's American Community Media Weekly National News Briefing. I'm Sunita Sarabji, your moderator today and co-producer of our weekly Friday briefings with my colleague, Pilar Marrero. Does a president with one stroke of his Sharpie pen get to define who is American? That is the question President Donald Trump has posed to us in the abstract on his first day in office as he signed an executive order banning birthright citizenship. Birthright citizenship is enshrined in the 14th Amendment and has been regarded as a right extended to any child born in the U.S. since 1868. Trump's executive order attempts to redefine the 14th Amendment and who can participate fully, that is, politically, socially, and economically in our democracy. The Supreme Court heard arguments from several organizations challenging Trump's executive order. Speakers today will inform us about what's at stake for our communities and the various attempts to fight back against an order that would essentially create an underclass of millions of millions of children, I should say, and render many stateless. We are proud to partner with Asian Americans Advancing Justice, AAJC, to present this important discussion today. So let's begin with Martin Kim, who will provide a broad overview on banning birthright citizenship and the lawsuit currently before the Supreme Court and AAJC's position. Welcome, Martin.
Hi, and thank you for that gracious introduction. Hi, everyone. As was stated, my name is Martin Kim. I use he, him pronouns, and I'm the Director of Immigration Advocacy at Advancing Justice, AJC. So I know that Professor Cheng will cover this in more detail, but I wanted to start just by very briefly highlighting what's at stake, what the historical context is on these attacks on birthright citizenship. And specifically, I wanted to mention that opponents of a free and open society have always seen jus soli, the idea, the principle of birthright citizenship, as a threat to their racist, exclusionary vision of the U.S. Even before the 14th Amendment, slavers in the early days of the U.S. pushed for a restrictive view of citizenship. And as I'm sure Professor Cheng will cover, the history of Asian American immigration and the Asian American population is deeply tied to birthright citizenship. So let's turn to what attacks we've seen. President Trump had issued an EO early in this second term purporting to end birthright citizenship for certain children. We have to understand that this idea, this attack, this executive order is based on a fringe theory, a fringe legal theory that tries to expand the one limiting clause of the 14th Amendment, right, subject to the jurisdiction thereof. But it is our position that the president cannot change the Constitution through an executive order, cannot just sign a piece of paper that says these people are citizens and these people are not citizens, because the 14th Amendment means what it says, and that's been held to be true since the late 1800s, right? Everyone born in the U.S., absent some extremely narrow exceptions, are U.S. citizens by birth. So there have been several lawsuits around this unlawful attempt to restrict birthright citizenship. 3 of those cases were consolidated and argued before the Supreme Court. And yes, of course, there are arguments in that lawsuit around the legality of what the Trump administration has attempted to do. But the core of the arguments yesterday were around a procedural issue and a main focus of the government's arguments, which is the limits that are present or should be present on nationwide injunctions. And that's because the 3 cases they were heard, they're coming out of an emergency appeal. And what that means is any decision we're likely to see is unlikely to reach the core question of the legality of the executive order that the Trump administration attempted to implement. Okay, so That's the birthright citizenship. That's the case before the Supreme Court. What's at stake? Sunita already mentioned there's an extremely large population of people that could be directly affected by the EO. The EO stated that that it would be future facing. It's not meant to strip citizenship away from people who are already citizens. But that being said, our main argument, what we've been saying as we've been responding to this EO, is that the idea that citizenship can be taken away based on the whims of a single person, President Trump, actually weakens citizenship for everyone, not just those directly affected by the executive order. And that's because we can see what this could lead to, right? The EO, of course, explicitly targets those individuals who are born to parents without immigration status, also those who are here on a temporary visa. But the actual argument that President Trump is making and his administration is making is that the president has the power to unilaterally decide who gets to be a citizen in the US. And that is obviously a very dangerous proposition. One last thing I'll say, of course, there are several Asian American groups that are interested in this issue that have been involved in the lawsuits. We are also, AAJC has filed a lawsuit as well. But part of the reason for that is, as I'm sure the professor will get into, a lot of the formation of Asian America in this country is based on birthright citizenship, right? The seminal case on this issue comes out of an Asian American's lawsuit against the government that tried to refuse that person's citizenship. So it is really historic and deeply tied to Asian American identity.
Thank you. Cesar Ruiz, before we begin with you, Mira Kaimal of India Currents has a question that I think you might be able to answer. Will the Supreme Court bench be hearing arguments about whether revoking birthright citizenship is actually unconstitutional or not? And if not, why?
I wanted to uplift one thing that Martin had stated in his presentation, which is really important. There are a lot of unknowns because one of the key questions that the court has to grapple with is whether the president has the power by virtue of executive order to change the Constitution, which presents a constitutional crisis in many ways. And we know what the law says in the amendment. We know what the law says in terms of the statutes in the NIA, and we know how laws have been interpreted. But to ratify this form of power and to give this power to the executive would create a lot of unknown, unintended consequences, because it would give a lot of power to the president to determine some of these very questions, and which is why so many groups have rallied around fighting the law. Now, to the second question, Martin also eloquently stated what is currently before the court and what will be before the court. So the narrow question that was before the court in the most recent arguments really dealt with what power does the court have to stop something that the president does? And does that have to be localized, or can there be national? And that was a key question that the court will have to reconcile with. And that's part of a larger fight about the power of courts to enjoin presidents, and a larger question within that. Now, Martin also mentioned that the court will be hearing this on the merits. It will be hearing the actual issues. But because this was brought through a mechanism known as an emergency appeal, it didn't reach the underlying question. So to answer your question directly, this will be heard by the Supreme Court. The timeline's not clear because the matter will be sent down, but this procedural question would be answered first, and then briefing schedules would be set, and then it would have to work its way through the appellate process. And that timeline right now isn't clear because the decisions are essentially caught on a pause until the Supreme Court decides this procedural issue. And so, yes, it will be heard. It will not be heard on a clear timeline until they know the answer to this piece of the puzzle, which is a procedural question, a technical one.
Thank you. And you were going to discuss the impact of banning birthright citizenship on Latino Americans and the lawsuit that you all filed in February. So please go ahead.
Yeah, thank you so much. I'm Cesar Ruiz. I'm Associate Counsel at Latino Justice. Latino Justice is a civil rights Latino nonprofit. We've done work across many areas, including democracy, immigration, among many other areas of our work. A key area of focus for us has been the attacks on the immigrant community, but specifically the Latino community. And we knew that much of the rhetoric that informed the current administration's policies on the campaign trail put an extremely large target on the Latino community's back. We heard a lot of the rhetoric targeting Venezuelans, Salvadorans, and we've seen actions consistent with this intention. Birthright citizenship is largely the exclamation point on actions that we've seen that dehumanize and that try and strip away rights from Latino and other immigrant groups. And so in February, shortly after the executive order was put in place, we filed a challenge in New York. Now, New York has a rich history of welcoming immigrants. Ellis Island has been a symbol of hope for immigrants. And so we thought it to be very important to file a challenge in a state where an institution in the fabric of life is immigrants. And we represent two organizations and two individuals. The first organization is the New York Immigration Coalition. The second is Rural and Migrant Ministries. And these are two organizations that have deep connections to the immigrant community and that have selflessly advocated for their needs, even in the face of stiff opposition that the administration currently enforces. We also represent two pregnant mothers. And these are individuals that are directly in the crosshairs and who would be having children who would be deprived of their citizenship. And as many folks have mentioned, be rendered stateless under the order. And there are essentially four reasons why we brought this case. The first, I think, as many have reinforced, birthright citizenship is a human right. It should not turn on where your parents were born or any other arbitrary factor. It's a concept that's embedded not only in the Constitution, but in our human history. And so we found it very important on the basis of our values and what we stand for, and also just the rights of our communities to fight that fight. The second is something that really is an egregious overstep by the administration to target the Latino community. We've seen attacks on Venezuelans. We've seen attacks on Salvadorans. We've seen deportations of individuals, even with permanent status. Kilmar Abrego, that case deals with a legal permanent resident who was Salvadorian and who went through all of the proper channels, but was still wrongfully removed. The administration admitted that, and there's still a fight to bring this person home. And so the birthright citizenship, as I had mentioned before, only continued that pattern and practice of targeting the Latino community. And this follows the administration using the media as a tool to villainize the Latino community through the targeting of Venezuelans, Salvadorans, and other Latino groups, saying that they are criminals, saying that we need to get them out of this country, saying things like they are poisoning the blood of our nation, things that stoke hate and fear, and things that directly have an impact on the lived experience of our community and the racial profiling that we know exists as a result. And so we really thought that it was necessary to take this stand. And we also recognize what Martin and Julia have talked about. There is no justification in the Constitution or in any of our laws for the position that this administration is taking. It is not supported through any statute. It is not supported through any constitutional provision. It is directly emboldened by the rhetoric of the administration and nothing more. And so we've really focused on the importance why, but we also want to uplift two more important points. We firmly believe that no president should have the power to simply rewrite our Constitution. That power is reserved for the people. And that power has not been vested in a president because that would create catastrophic issues. The fourth is that this is an issue that would fundamentally undermine all of the rights that flow from citizenship. It's not just the issuance of a birth certificate, but all of the rights that flow with that Julia, I think, so eloquently talked about. It is the right to work in this country. It is the right to travel freely. It is many of the privileges and things that we take for granted, but that flow from the virtue of you being declared a citizenship. And so citizenship is preservative of all of our rights. And it's something that is really important that we protect. And we brought this case because we thought it was important to speak to these issues in a way that humanizes the struggle of immigrants and that humanizes the issue, but also that maintains a bright line, that it may be this small targeted group today of individuals identified in the order, but there are seemingly no bounds to where this could end. And I think a lot of the questions that folks have raised those very questions is, if we're starting here, where do we go? And then it's for those reasons that we really sought to fight. So I'll pause there. I've said a lot for any questions that folks may have.
Thank you, Cesar. Speakers, note that there are a bunch of very interesting questions in the chat, and if you could answer them there, that would be terrific. Our final speaker today is Professor Robert Chang, who will provide a historical perspective on birthright citizenship. Welcome, Bob.
Hi, Sunita. Thanks so much for having me. And there's so much to talk about. And I was asked to place this in historical context. And so when we think about this effort by the current president with regard to birthright citizenship, it's not something that is isolated. It's connected to the long history in this country. And so when we think about this, at the founding of this country, who got to be full members of this political community? Now, the Constitution itself does not say anything about eligibility for citizenship. It does say something about naturalization. It directs Congress to create a uniform law of naturalization. So what did Congress do when it used this power? In 1790, it created a law of naturalization that permitted free white persons to become naturalized. So free white persons, that's what Congress did. From the beginning, it restricted who could be full members of this community. And then many people may be familiar with the case of Dred Scott versus Sanford. And this is a case in 1857. And the question was, and it's funny because it was actually a very technical question about whether or not a Black person could sue in federal district court. Because in order to sue in federal district court, he had to have been recognized as a citizen. And Chief Justice Roger Taney, in that opinion, said that Black people, regardless of how many generations they might have been free in this country, could never become citizens of this nation. And that actually precipitated a crisis that led to the Civil War. And then following that, there were attempts by Congress through the Reconstruction Amendments, the 13th, 14th, and 15th Amendments, to address this. And so the 14th Amendment was intended to undo the harm of Dred Scott and this notion that Black people could be full members of this national community. Now, it did leave certain questions unanswered, including, okay, so now that Black people can be recognized as citizens, well, I guess we need to change our law of naturalization. And so Congress did that. And it allowed then white persons and persons of African nativity and descent to be naturalized. Well, okay, so what about people who look like me? What happens to people who look like me? Well, in 1882, in the Chinese Exclusion Act that forbid laborers from coming into this country from China, there was an explicit provision, I think Clause 14, that said that Chinese persons could not become naturalized. And so then, okay, so we can't become, people of Chinese ancestry can't become naturalized. What about their children? And that's when we get to the 1898 case that's been referred to of Wong Kim Ark versus the United States. So he is born in the United States. Is he a citizen? And the US Supreme Court in that decision said that yes, that was the interpretation of the 14th Amendment. He was born in the United States, subject to the jurisdiction, and therefore he's a US citizen. And since that time, and I don't have time to go through some of the other cases that confirm this, but we have an unbroken chain of 127 years of the recognition of birthright citizenship. But throughout this, there was still the effort to limit who could become citizens, because What about people who look like me? After this, could we become naturalized? And this is when, in 1922, the United States Supreme Court in Ozawa versus the United States said that a Japanese person could not become naturalized, even though he came to court and said, I'm white. He presented his skin to the court and said, I'm whiter than European immigrants that you let become naturalized. The US Supreme Court there said, well, white equals Caucasian, so therefore you lose. Well, the next year, a South Asian man came to the court and said, I'm Aryan, I'm Caucasian. You just said Caucasian equals white. I should be able to become naturalized. The US Supreme Court said, no, white equals somebody who does not look like you. Now, this has a devastating consequence, and this is critical in understanding a possible risk with regard to the current executive order. And so following the denaturalization of Bhagat Singh Thind, the U.S. Department of Justice instituted denaturalization proceedings against the 60 to 70 South Asians who had been able to become naturalized. And so when we think about this executive order, sure, it said that babies born on February 19, 2025 and after do not have automatic birthright citizenship. But if the U.S. Supreme Court upholds this executive order, it creates the risk of the possibility that everybody who has parents in those two categories who thought they were U.S. citizens, well, they could have the U.S. government denaturalize them. And so that's one of the risks. And that's the argument that we made in the Ninth Circuit on the merits in an amicus brief. So the Korematsu Center, working with the Center for Civil Rights and Critical Justice at Seattle University and with Asian American Legal Defense and Education Fund, we pose the risk because we know what history has produced for us. And so then when we think about what is really at stake, it also goes back to Cesar's point about voting. I think this has to do with undoing the voting rights of everybody retroactively who falls in these categories, because states are responsible for registering voters. And so if a state wants to act on the executive order, they could say, okay, well, if you want to vote, you have to prove that your parents don't fall into these two categories. And if you can't prove that, then you can't register to vote in that state. And so there's all sorts of mischief that might be produced. But again, getting back to the historical perspective, this has to do with controlling who gets to be full members in this community. And this goes to a long strand of history where people of color have been targeted, either in terms of not being able to become citizens by birth, or through naturalization, and this is just one step. If birthright citizenship goes away, well, who determines who can become naturalized? It's Congress. Okay, so it goes back to the political branches. Once this is restricted, it opens the door to other limitations in terms of who can become naturalized. The stakes in this are so great, and that's why it's amazing to be part of an advocacy community that is fighting hard to make sure that this doesn't happen. And so I want to stop there because I hope I haven't gone beyond my 6 or 7 minutes.
You have not. Professor Chang, could you just talk a little bit more about how this opens the doors for, who can become naturalized? And to all of the attorneys on this briefing, do you see a process of reversal where people who have been naturalized have their citizenships revoked?
Here's how the federal government could put this into action. So let's imagine somebody has a US passport and they want to have it renewed because it has expired. So then the US government could require, so the State Department then, so there could be a new executive order. The president says to the State Department, in order for any new passport to be issued or the renewal of any passport, the applicant has to prove that their parents don't fall into these two categories. And if you can't prove it, then you don't get the passport. They haven't technically denaturalized the person, but they've taken away one of the really important benefits that come with citizenship, which includes the ability to travel abroad, the ability to visit family and friends, the ability to go enjoy what other countries have to offer. So that's one way, without going the full denaturalization route, that they could use this to take away like little bundles of things, the rights that come with citizenship. But given the past history, if the Department of Justice wanted to denaturalize or possibly even engage in citizenship stripping, history teaches us that they've done it before, and this current effort is actually connected to those earlier efforts. And that's why many of us are so fearful about this. And part of this also is, even if they don't win this round, it softens the ground for future efforts. It raises the question, should we really be, should we rethink what it means in terms of birthright and citizenship and who gets to be part of this nation? It opens up this question in a way that I think is very dangerous during this political moment.
Thank you to all of our speakers. We could spend at least another hour on this topic, if not longer. But I very much appreciate you all for being here. And reporters, we'll see you next Friday. Thank you again.